SJC-13295 in the matter of an impounded case.
Okay, Attorney Lord.
Good morning. May it please the court. My name is Buffy Lord. I'm from Donovan, O'Connor, and Dodig, and I am here representing the biological father. We are asking that the court reverse the trial court judgment and remand the matter for further proceedings, including confirmatory DNA testing and a hearing and determination as to the parental rights and obligations of all three parents at issue in this matter. The biological father in this case has standing to proceed under Chapter 209C or 215 because the child was born out of wedlock, and there are complaints filed under both chapters.
Is there a reason with regard to the timing why this is happening now? It's not as if he didn't know about the child.
That is correct. He did know that mother had a child.
Yep.
In fact, he and mother share a child together. At the time the child was born, mother expressed to biological father that he was not the father and that in fact somebody else was.
Did he ever like ask the next question? How do you know?
He was aware that she had engaged in sexual congress with other men.
But no, I'm saying, how do you know it's not me? How do you know I'm not the father?
Yes, Your Honor. I believe that he left the implication as to the timing to the person who in fact has the biology to know the likelihood of conception based upon...
He didn't ask the next question.
I don't believe he asked the particular day she thought she conceived.
Well, no, I don't mean for, I just mean, I don't think you have to ask what day did you conceive to be more curious about, is there a chance? I'd like to know, I'd like to hear more.
Yes.
If I might be the father, I'd like to hear more other than, no, you're not the father.
Yes, Your Honor, and I think in this case, one of the things that I would point out is that he had reasonable reliance on her. She admitted that she'd had intercourse with other people. She had had a child with him before in the past, and when asked if he was the father, she in fact answered in the affirmative. So I think that it was reasonable for him to believe that she would tell him the truth.
And the truth as she believes it to be, or just
I think the truth is she believes it to be, Your Honor. At the time, and as you can see from the history set forth in our brief, she in fact thought that there were two other candidates that presented a more likely option. Our client, I don't know that the record knows that he knew that there were three other candidates. The record does not indicate that he had any knowledge at any point that she in fact tested and excluded other people, which then, of course, I think would increase the chance that maybe he should have asked more. But if you don't know...
But if he'd wanted to find out if he were the dad, he could have absolutely done so, right? We want people who may be dads to come forward, and he had a way of doing it at the time, and he knew he was in the ballpark of 9 months that right? He certainly could have found out whether he was dad.
Your Honor, he could have filed a complaint for parentage.
If he wanted to make sure, he could have. He wasn't looking to find out whether he was or he wasn't, right?
I think I would be hard pressed to say that he took her to court. He did not do those things. He relied on her representations. I think he was reasonable to do so.
I'm sorry. Go ahead. Finish.
And I would say that, to the extent that he is now precluded from coming forward because somebody signed an acknowledgement of parentage that they knew to be inaccurate.
But that was my other question is, signing one of these VAPs, is it a statement of biological parenthood, or is it a statement of I acknowledge parenthood in a broader sense? Because especially in the modern world, we've been very accepting of these from people who couldn't be the biological parent, right?
Correct, Your Honor, but the form itself states that it is under the pains and penalties of perjury.
What are you saying?
Exactly?
Yeah. When you say that, right, sorry.
It affirms that under the pains and penalties of perjury that you believe your statements on the form to be true, and then the statement is that you are in fact the biological parents of the child.
And it says that on there? It says biological parent?
It does on the form that was signed in this case. I do know that there is now an alternate form that is available. And what that form allows is, first of all, it has gender-neutral terms, so it doesn't say mother and father, it says parent one, parent two. And then when you get down to the boxes where you begin to check, the first box that the parties can check is that you are the biological parents of the child.
So was I'm sorry, just to clarify, that new form was not available at the time?
It was not available at the time, Your Honor.
Were there other forms that were available to this?
As far as I know, this was the form that was available from the state, and if you
Okay,
wanted to proceed.
So in order to do the VAP, this was the form available?
Correct.
Okay.
And as was pointed out by Justice Kafka, yes, my client, in fact, could have filed a complaint for parentage, and I cannot state otherwise.
What would be
Like-
the impact, though, now of saying, okay, you're right, he's got the responsibility? Is there any retroactive child support issue?
Well, I don't believe so in this particular case, because there's been no child support paid by either, I'm going to call
why
them
would that
biological
matter?
and legal father
Why
for
would
now.
that matter?
Because there's been no order, so there wouldn't be a retro award available, I wouldn't
But somebody
believe.
could seek it, couldn't they?
They could, and that could be on a case-by-case basis. And back to the point I was making earlier is that although my client did not, in fact, file a complaint for parentage, neither did mother and legal father in this case file a complaint to adopt or a petition to adopt, right? So acknowledging, I agree.
That's expensive, though, right? This is, the VAP is every person's ability to become a parent, as opposed to adoption, you need a lawyer, you gotta, it's a much more productive.
Because you're terminating somebody's rights. And so, as I was saying on the VAP form or the form that presently exists, although I'm going to also admit that I had trouble locating one that didn't have sample stamped across the top. I don't know if it's just a function of being a layperson versus having it available at a hospital or another thing. The first box that can be checked is that you are in fact the biological parents. The next box lets you check that you, rather than being the biological parents, in fact, the child was born through assistive reproductive technology. So that allows someone to come forward. They are not the biological parent, but they are the parent of the child. And again, we're recognizing that when someone uses assistive reproductive technology, that the person donating biological material at the time is either an unknown donor and the person went to a clinic and, thus it's an arm's length transaction and we don't know who they are, or if they're a known donor, we would anticipate that the parties would have an underlying agreement that says, I'm donating material, there's a hope or an expectation that there'll be a child, but I understand that I'm not maintaining a parental interest in this child. And so we would argue that in this case, we have a child born out of wedlock. The plain language of the statute under 209C only prohibits a putative biological father from coming forward if the parties are married at the time of conception or birth. So, our first argument is that our client should have been allowed to proceed
I
under.
think that statute's is still constitutional, in light of everything now.
In light of the decision where we have to read the statute gender neutral and yes. So the word married is still the word married, and all people, regardless of their sexual orientation, can get married. So it says married.
Okay.
But I would,
we can leave it
to
there.
that end, we would argue that in fact, if what we are saying is that any time there is a legal father on the birth certificate, so if we extend it past there, our argument would then be, okay, there is a legal father on the birth certificate. So question one is, did we execute this in good faith, right? Did we believe ourselves to have been a parent? And if we're not the parent and we don't have an underlying agreement and we have some knowledge that it might not be, I would argue that my client is not the person who disrupted the family unit. It's the people who
But
signed
what's
it.
in the best interest of the child, though? Don't we have to reach that and
Well, we
really
don't-
seriously consider that here?
I actually agree, Your Honor, but we don't get there. Because in what happens now is that if you file under 209C, again, if we presume we went forward under 209C, the first thing would be a hearing where we where there's a finding about whether or not by clear and convincing evidence there's a possibility of paternity or parentage. Once that determination has been made, Section 17 requires a confirmatory DNA test. And then, although the statutory scheme doesn't say it, the next phase would be a hearing on what's in the best interest of the child. And we agree that the nature and extent of any prior relationship is a big factor in what's in the child's best interests. But we don't think it's the threshold inquiry, and that by treating it as such, we've created a bar to somebody coming forward. So likewise, I would go so far as to say that even in a case that's brought under 215, even in a case where you have the presumption of parentage based upon marriage, I think that it would be appropriate for a third party to be able to come forward if they have a belief that they're the parent, and that they would be entitled to the hearing on whether or not there's a possibility they were a parent.
Even though, in this case, there's no doubt, again, he knew he was in the realm of possibility. He knows the mother, he knows he was sleeping with the mother around that time. So why should we let him sit on his rights that long? I understand, yes, if he'd been shipped out to sea and, incommunicado for a year, maybe this might be different, but he's not. He knows about this, and he could have done something about it. And now we're allowing him to come back 6 years later or whatever.
We're allowing him to come back. We're allowing him to have status as a parent. That does not mean that he is going to have the same parental rights as the other two parents. I feel that we keep...
No, but the Judge Simons does something that seems very sensible. If this had been filed within a year, then we're in a different category. But if he waits 6 years, then we apply this substantial connection, or whatever the proper terminology is. And it seems appropriate, because why are we having him become a dad after 6 years when he could have been a dad within, 6 days of the birth?
I understand, and I presume to some degree there's a focus on layer, which is, you have to grasp your parental responsibility. The argument there is that, yes, he was one of multiple possibilities. He was told it wasn't likely, and I think it's reasonable that he rely on that. Instead, we're saying that we would rather have more litigation when the parties were frankly parenting. Our client actually, although not as close a relationship as it is with legal father, as again, I'm just trying to make sure it's clear, they have a relationship. They've spent holidays together. He spent birthdays with her. They share a sibling. In fact, both legal father and biological father have another child with this mother. So this family unit is changing, and it's large. And I think that that's part of the problem with the cases as they exist, is the cases are all stem from this idea that the societal impact of illegitimacy is so terrible that it must be avoided at all costs. And they also seem to relate to this fiction that there are these intact, traditional, quote unquote, normal family units. And I think that
I don't know if that's the case. I think you're sort of turning it on its head a little bit, because this Mr. Mercer steps up. Now, you look at it, what he's done is problematic, but because, and again, we're going to ask your brother when he gets up, essentially, is the VAP process limited to biological or assisted reproductivity, or does it allow this third category of person, which is basically, I want to help out, I want to be a dad. I want to be this dad because I'm basically acting as this dad.
I'm sorry, Your Honor.
No, go ahead.
I would argue that, in fact, I don't find legal father stepping up to be problematic in the sense that all children need all the parents and all the family they can have to be supported. And I think that the VAP could be changed, but the VAP form as it exists does not state that. But
The statutes say it, or just this, the happenstance of the clerk's office putting together this form that way? Does the statute say you're the biological parent, or is that the clerk's office embellishment of that?
I do not know, Your Honor. I'd be happy to file a supplemental material under Rule 16 if you would like on that issue.
I remember looking around at the statute, and I didn't see the word biological. And then I was looking for the form. Is the form actually in the record? I couldn't find it, and I didn't.
I believe the form is in your record, but again, if the court would like, I would be pleased
I
to
hope
send
it-
you both versions of the form under the supplemental materials rule.
I think it is in the.
Okay, you found the form?
I believe it is, Your Honor. But so I would again argue that, in this case, far from trying to deprive the legal father of status, that we would in fact think that the court should hold a hearing as to the best interest of the children. And there's no prohibition on a child having legal and physical custody with more than two people. I would point to the 1944 case. Sorry, I apologize as I flip pages. That discusses that issue. In fact, they had more than two parents. So, and the one last point I'd like to make, I realize my time is running out, is that as it relates to de facto parent status, there's some concern that, and we use the term de facto status for where we think legal father might fall into. We don't intend or believe that a de facto parent should be a second-tier parent, or as has been intimated in some of the briefs, that it's some lesser class of parent. There is no statutory authority for de facto parents. It is a case law animal, and there has been no finding that, in fact, legal and physical custodial rights can't follow de facto parent status. So, we think that when we look at the evolving family, that a child can have more than two parents, that some will be biological related, some will not be biologically related. We don't intend to cut out any of the family units. What we're simply saying is that the substantial relationship test is not the threshold burden. That is one factor that goes into the best interest of the child standard. But first, we have to get past the gatekeeping function of the court, which is
I just ask a
Yes, Your
question
Honor.
about that. So it's not under 209C, but is it under 215?
The substantial relationship test, Your Honor? Yes, that test, so the General Law 215, Section 6, is the general equity powers of the court. There is no express statutory authority for the substantial relationship test or when it applies. It's, again, a function of case law.
Yep.
And in those cases, with the substantial relationship test, we had somebody coming into a marriage. And again, I would point to the fact that, we have outdated notions at that point of family, and it stemmed a lot from societal implications.
But I guess I just wanted to know, that's what we use, the substantial relationship test for.
Children born in wedlock, where somebody is coming in that is not the husband seeking to establish parentage.
That's the only time we use 215.6?
Well, that's the only time we use the substantial relationship test, Your Honor.
Oh, okay. And how come we're not looking at this 1 year basically statute of limitations in 209C?
Right, so we've got that one portion of the statute relates to rescission, right? So the parties can, for any reason,
Yep. And then after
rescind,
that-
right? And then we would argue that that 1 year limitation period, again, is treated like, as a function between the parties, right? It's not to
Why would
all
they-
world as
why-
to all
but
notice.
why would it? Why would it? It doesn't say that in here. It just says it's subject to challenge within 1 year only. In fact, I'd argue that it would be anybody but the people who have entered into the agreement because they did so voluntarily.
They did so voluntarily, and I think within the year, the parties who entered the agreement, again, have that fraud, duress, mistake, because you might learn something. But as to the public at large, part of the challenge is that nobody knows when VAPs are signed. So, for example, a putative biological father may have an ongoing relationship with the child. Maybe didn't sign a VAP, but there's a relationship. And the mother can have somebody else sign the VAP. And it gets filed with the court, the birth certificate gets changed, and no one may ever know. or may only know 5 years later. So I think that that's part of the challenge, Your Honor.
Understood that, I get that. But then I go back to the 215, Section 6, which I know you're saying usually is only used in this one particular way, but does that mean it has to be used only in that one particular way?
But again, we also proceeded under 209C, and
No, I
that test
understand.
isn't there.
I understand you did.
So again, we argue that the substantial relationship test should not be applied in marital or non-marital cases. We really believe it's an outdated, outmoded test in that it was meant as a bar because the idea was to preserve marriages. And
Substantial relationship test?
yes, Your Honor. That is how that case arose. For example, there are two cases. The biggest one that I think of is we had a woman who had an extramarital affair after the child was born. For the first 4.5 months after the child was born, the biological father came to the house every week, gave money. And when mother broke off the relationship, he still wanted to see the child. He set up life insurance. And it was within a year, and the court said, no, there's no substantial relationship. And I find it hard to believe that when you're talking about an infant, that matters. The best interest of the child matters. And the best interest of the child, that prior relationship is a factor. And in fact, in the Lair decision from the Supreme Court, which we don't necessarily agree with on all points, but Justice Scalia noted that it was one factor in the best interest of the child. It's not the whole test. So we would argue that our biological father should get in the door, there should be confirmatory testing, and then there should be a hearing, and the hearing should determine, in fact, the nature and extent of parental rights to each parent, not limiting it. We are not seeking in any way to prevent current legal father from parenting this child. We recognize this isn't a zero-sum game. This is a child's life. They'd have a right and an interest in knowing their biological family, their lineage, having all of the parents and all the support that they can have.
Well, can't that
Yes,
all
Your
be
Honor.
provided without this official acknowledgement? I mean, there's no reason the father can't participate and I mean.
But the
biological
court,
father.
but the court
And
didn't.
has been
And has
participating.
been, right.
The court-
I mean,
right.
all that's there.
But the court did not enter, he has no custodial right that can be enforced, so that if either of the mother or current legal father were to say, you can't see the child, the answer is he can't, because he has no ability to go into court and argue that that his relationship should have
Have
protection.
any even weigh in through equity in the probate court to say, look, for the last 3 years, they've brought me into the family and I am the bio dad.
No, Your Honor, not under the current law.
Even if he had a significant relationship?
If he had a pre-existing significant relationship, so there are some cases, in the cases that I've read that have that pre-existing relationship, tend to be children born in wedlock, but they were separated at the time. And so there was this window where biological father lived with mother and child. It has not been, I have not seen cases where you can come forward, for example, he learns when the child is 7, in fact, it is yours, other people have been tested, as in this case, he's seen the child, for most of the child's life, in fact, believes, knows that his son is related, and yet that's not a relationship worthy of protection, even on a one afternoon every 2 weeks kind of basis at this point in time. So I think it's
I think I have my answer. Thank you.
Yeah,
Thank you, Your Honor.
Thank you so much.
Thank you.
Okay. All right, Attorney La Rochelle.
Thank you for your time this morning. And may it please the court, I do want to point out I'm not the legal father, even though Attorney Lord pointed to me a number of times when she was talking about the legal father. But I do represent the legal father of a 9-year-old girl. And in this case, the putative father, at least in the briefs, has claimed that he has a constitutional right to parent this child on the mere fact that he shares DNA with her. The biological father is wrong on that. The United States Supreme Court has made it clear, both through the Stanley versus Illinois decision, and then even clearer in Lair versus Robinson, that it is not just DNA alone that gives a parent a constitutional right or a liberty interest to parent a child. It is siring, and this is a quote from the court, siring and raising the child. And the raising the child is totally not here in this case. But because that is a constitutional concern, the probate court was exactly right in ordering and holding an evidentiary hearing on the question of whether there was a substantial parental relationship with this child as a gateway to any of the proceedings before it. It does two things. Number one, it satisfies this court's requirement set down in CC versus AB to have such a hearing and to determine whether there is a substantial parent-child relationship before proceeding on the merits of the case in an equity case. The second thing it does is it answers the constitutional question of whether there is a substantial relationship between the child and the parent that rises to
But
constitutional.
I get all that. I'm a little concerned with the original, the VAP, on your client. Does the statute, I mean, is this a misuse of the VAP process or not, I guess is the question for me. And both in terms of what the statute says a VAP is and what this clerk document said it was. Could you talk me through those two things?
I
Because
can-
that's what makes this more complicated.
I can, Your Honor. And by the way, the VAP is included. It's in Appendix Volume 2, page 7, I believe, is where the actual signed VAP is. And if I could make really 4 points on the VAP, I appreciate it. The first one is that in the briefs anyway, we talked about fraud, or they talked about fraud.
Could you start with the statute? Because it's nice to know the law. What
Sure.
is a
The
VAP?
statute is 209C.
Yeah, 209C.
Section 5 and 11 specifically. And Your Honor is correct. You mentioned earlier, there is no mention of the VAP being limited to a biological parent. It's absolutely not existent in the statutory law. It's not existent in this court's case law up until now. In fact, originally in Paternity of Cheryl and later on in the Partanen case, this court found that it's perfectly acceptable to be a parent and in the Partanen case to sign a valid VAP.
And were those sort of pre-Goodrich cases and dealing with the artificial insemination issue, or what were those cases? I'm just trying to understand, because I take it, we don't want anybody just filing a VAP, right? There has to be some, is there a limitation on it, or can anybody just, volunteer for the duty?
Well, there's a limitation on it in the fact that the person who is going to sign it, both the mother and the father-to-be have to sign it, and they are both obligating to parent the child together. And so for the person who is stepping up as, in most cases, the putative father, as the to-be legal father, that person's taking on intense responsibilities that will carry forward with him for the rest of his life, certainly through the rest of the child's minority.
So
In
if
fact,
anyone,
the
if
statute
you're willing to,
requires.
if you're willing to do it, then that's, and the other person is willing to have you do it as well, those are the limitations. It's not biological or a product of artificial insemination. That's not the driving force of a VAP.
It's absolutely correct, Your Honor. There's absolutely nothing in the statute that requires it. There's nothing in the case law of this court or the state of Massachusetts that requires it. And in,
Yeah,
Justice?
so this father, biological father, isn't really in the best position, but I guess my concern is, and I don't know if you read the Veterans Legal Services amicus letter, which was really thoughtful, is what if the VAP is signed by somebody who doesn't necessarily have that much of a connection? I mean, the mother here a couple of times was manipulative. Let's say that you have a situation where you have a biological father and he's not doing great in life. There's always the possibility of redemption. He's the biological father, and he's now in a position in his life where he really wants to be a father and take care of his kid, and he doesn't have a substantial relationship. He's not going to go anywhere under Chapter 215. He's not even going to have a chance to be able to demonstrate that redemption and that real desire to be the father of his biological child.
Well, I think that's right, Your Honor. As Justice Cipher was pointing out, I mean, that biological father still has the ability to help. He still has the ability to provide financial support if he wants to. He has the ability to leave money to the child in his will if he wants to. He has the ability to be there for the child if the child wants to come to him and with
to the
problems that
extent
she's
that,
having.
and to the extent that the parents allow that.
And to the extent that the parents allow that, that's right. But what this court has always recognized in all its jurisprudence, and it should not change that here, is that the primary interest is the child's interest. So how could it possibly be in the child's interest, 8 years, now 9 years after she was born, to have a court say, this man that you've always known to be your father is no longer your father, this other man is. And
I get that. I get your facts.
it's even, it is perhaps.
I understand your
Apologies.
facts. They're compelling. I get it. I'm just wondering about a principle here of law that where the father on the VAP is not father of the year, and you have the biological father who is in a better position than he ever has been before, maybe did a lot of work to get there, and wants to be able to establish that relationship, and with an obstacle that he doesn't have a substantial relationship, he never has a chance.
Unfortunately, Your Honor, the law, as it stands, and I think it's based on solid grounds of recognizing the primacy of the children's right first, would not give that biological father you're talking about, or that the VA talked about in their brief, would not give that father an ability to establish a formal parenting relationship with the child, unless the father who did step in, the legal father in that case, was found to be an unfit parent and was stripped of his parental rights. Unfortunately, because the child's rights have to be superior to the rights of this biological father, there's no other way around that. I just don't have a better answer for you on that, Your
It's complicated here because the child's interested in who her biological father is, right? The child, your client has told her, I'm your father, but I'm not your biological father.
Yes.
The child is at first confused and then interested. And the judge has to, does the judge take, when the judge does the substantial connection process, the judge has to take that into account too, right? Because does the judge take that into account, that, look, this child is curious? I mean, a lot of people who don't know their birth parents and are adopted by someone else want to know something about that person. So how does that play into
Well,
this?
I think that's right, Your Honor. I think children are curious about who their biological parents are, and there's ways that children can find out who their biological parents are, which stop well short of making that biological parent their new father, as opposed to the person who's been raising them for all those years. So that's not part.
To be fair to your opponent, they're saying they want to be in the game. They don't want to take over the game. They're not saying that your client is no longer the father. They're saying, basically, I want to be a dad too.
Well,
You know, I mean, I understand that that's complicated.
it's complicated because, as Justice Cipher was saying, that the biological father, the alleged biological father, because there's no evidence in front of the court that he is the biological father yet, he has the ability to participate in that child's life to the extent financially that he wants to, and to the extent that the parents allow him to be. But what he's seeking for here, by an adjudication of parentage, he's seeking a seat at the table. He is seeking at least the ability to ask the probate court, dictate to the parents what this child's life should be like, what the decision should be made for this child. That he's not entitled to. He may have been entitled to, he would have been entitled to that had he proved his parentage within the time allotted by 209C.
Speaking of that, what effect does that have on standing?
On his standing?
Yeah, his standing to bring this on that 1 year.
Well, under 209C, he has no standing to bring this because the 1 year is passed, and that is strictly a creature of the statute, and there's no leeway on that. With respect to his bringing his equity claim, he does have the ability to bring that anytime, but he has to pass this court's CC versus AB, substantial parent-child relationship test to do that.
I thought you were going to say some more about the VAP. Did you say you had 4 things to say?
I did have 4, and I'm not sure how many I actually
You
got
only
to.
got to 1.
But the first one is I
No, I
don't,
don't even think you got to 1, because before you got started, Justice Kafka asked about the
It's
statute.
my fault.
Well, the first one is-
I
No,
apologize.
no, and then Justice Lowy interrupted you as well. Go on.
I appreciated the interruption. The first point is that we shouldn't be talking about fraud or perjury anyway, because there's absolutely no evidence in this record that there was an intent to deceive, nor is there any evidence that alleged biological, and I pointed to her this time, she's not the alleged biological father. There's no evidence that the alleged biological father actually relied on this VAP. He never saw it. But the second point is perhaps a more important one. At the time this voluntary acknowledgement was signed in 2016, as we've already talked about, 209C, the legislature has already not required a biological connection to sign that form. And this court, in the Partanen case, basically said it's not important for you to be a biological parent to sign this form, and we're going to uphold this form even if you're not the biological parent. So when this form was actually signed in November of 2016, it was the law of Massachusetts, as expressed by this court, that it's okay to sign that form even if you're not the biological parent.
But Partanen is the California case, right?
No, Partanen's the case in front of this court, Your Honor.
No, but it involved the woman taking the child to California or Oregon?
It's
it
the.
doesn't really
It's the
interpret-
same-sex parent case, yes, Your Honor.
Doesn't really interpret this stuff, does it? It doesn't interpret VAPs or anything else. I looked at it because I thought, oh, this is going to be simple, but it's kind of tangential, isn't it?
It doesn't specifically say that, but it does, the court does uphold a VAP which was demonstrated to be not signed by biological parents.
So there was a VAP in that case?
Yes, there was.
Okay, yeah.
Okay? And the third point,
So in that case, it's a gay couple and it's an artificial insemination, so it's a little different, right?
we're still talking about non-biological, or a biological parent as opposed to a non-biological who had taken control of the child's life. The third point I wanted to make was that if this form did contain a misstatement, which it did, the legislature who created the whole mechanism set forth exactly what the remedy is to resolve that misstatement. It's to challenge the form within 1 year of signing. That's it. And in this case, it was not challenged within 1 year. And the 1 year is really important because the legislature made the decision that after 1 year of someone else, the person who signed the VAP, acting as this person's parent, establishing a parent-child relationship, it's not in the child's best interest to in any way challenge that VAP now and say, well, maybe this person you've come to rely on, maybe that person's not really your dad. We're maybe going to give you a different dad.
But that includes whether the bio dad knows anything about this or not, whether the bio dad has been around, as in this case, and might have been able to look into things, but didn't. I don't know if he ever could have found out. But what about the person that Justice Lowy pointed to, the example of somebody who's been away, knows nothing about a VAP being signed, and loses his chance because he doesn't know about his chance?
Two things about that. First of all, it's clearly not this case because
understand. I
this
understand.
alleged father did know. The second thing about that is, you mentioned earlier on questioning Attorney Lord that it was a statute of limitations. I don't think it's a statute of limitations. It's a statute of repose. It's repose for the child to be able to rely on the fact that the person who's been her father for at least 12 months will continue to be her father.
I'm not saying that anything should happen to that. It's just that what I'm trying to understand is under Chapter 215, that a substantial relationship, even if you're not trying to displace the father who's on the VAP. No one wants to displace the father on the VAP in my hypothetical. Father's doing a great job. It's just some person who didn't know anything about this or was not in a position in his life, he had issues that he's come back from, hoping maybe to be able to have parenting time even if the parents don't want them to, it's not that that judge should order that, it's that the judge never can consider that because the threshold for substantial relationship can't be satisfied
Well,
under 215.
The substantial parent-child relationship relates to an actual adjudication of parentage, not a de facto parent, not an adult who's coming in and asking the court, I need to have time with this child because it's in the child's best interest. This case was not brought by the putative father as, I want to be the de facto parent, I want to have parenting time. That would be a different analysis. And in fact, in that case, you wouldn't have a substantial parent-child relationship threshold. You would just have a best interest of the child threshold or standard that you'd have to meet. But that's not this case. That's not
Wait,
the
what is
posture of
that
how this
case,
case
though?
was brought.
What's the statute under which a person who wanted to do that?
I don't even know if there is a statute, Your Honor, but that's how the probate courts have handled it.
It doesn't matter if that's not this case, if there's no other vehicle.
But isn't the only, there's a 209 vehicle and a 215 vehicle, right? You're either in the 1-year vehicle where you can prove that you're the parent, that you're a biological parent, or you're in the 215, right? There's not a third road here, is there?
Not to establish legal parentage. No, there's not.
Right, there's only those two
And
roads.
isn't the reason for that is that time is of the essence for children?
It really is. I mean, there is an interest that certainly the child has, but everyone has in a finality of a paternity judgment. Because if we wait too long and the child develops this relationship with a new man and doesn't know this stranger to be her father, it becomes more and more damaging to her the longer we wait. The legislature has set 1 year on 208C, and this court has set the substantial relationship test as being the standard on cases of equity. And those standards both protect the child primarily, and that's really where this jurisprudence should be. It should be in the interests of the child.
Are they mutually exclusive? Because no, I'm not interested in displacing a father and it not being in the best interest of the child. The best interest of the child is what it's all about. But are they mutually exclusive? Does that mean a biological father who would have no way to know and wouldn't be able to establish a substantial relationship? There's no third door. It's 209C or 215, right? That father doesn't have a chance to say, well, you know, I'd like to be able to see the child every 2 weeks or something.
That's correct. I believe that's correct, Your Honor.
That he could do that through asking the parents.
Always through asking the parents. That's always an avenue, but not through the courts. That's correct, Your Honor.